Very much. My name is Michael Maharrey. I'm the National Communications Director for the 10th Amendment Center, and I'm very honored to be here with you guys today. I'm going to address the Attorney General's opinion on this particular bill. As you probably know, in the opinion of Attorney General Robert Cooper, SB 250 violates the Supremacy Clause of the Constitution. And I've read his opinion, and his basic reasoning is very solid. Nevertheless, he came up with the wrong answer. Now, I'm sure you guys all remember working those long quadratic equations back when you were in high school algebra class, and you know that you can work all of the steps absolutely correctly, but if you do an addition or subtraction error in your very first step, you're going to come out with the wrong answer. Why? Because you've worked the problem working from the wrong premise. Cooper spends the bulk of his opinion correctly arguing that constitutional federal law trumps state law where it conflicts. Quite frankly, that was a waste of time. Nobody disputes that. The problem is that he incorrectly assumes that every federal act is constitutional law, and he builds his opinion on this fallacious premise. Fact: only laws made in pursuance of the Constitution are truly supreme. All of the Founding Fathers agreed, and I mean all of them, that any federal act that violates the Constitution is no law at all. Hamilton summed it up in Federalist 78. He said, every act of delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution can be valid. Cooper apparently wants the people of Tennessee to believe that the following federal acts mentioned in Section 5B of SB 250 are constitutional and therefore supreme: a ban on firearms, tracking of ammunition, federal taxes on firearms accessories, among other things. Where exactly does the Constitution delegate the federal government power to regulate firearms? It doesn't. Now, some will argue that there's some regulatory authority under the Commerce Clause. But we have the Second Amendment. And the Second Amendment puts further restrictions on the federal government. And we have to keep note of the most important phrase in the Second Amendment: shall not be infringed. Infringed means to interfere with. That leaves no wiggle room. Now, Cooper mentions the possible unconstitutionality of these acts almost as an afterthought. He writes near the end of his opinion, while the bills themselves declare that certain federal firearms regulations are unconstitutional, the responsibility for that determination rests with the judiciary, not a state legislature. Now, the Attorney General rests his argument on the Marbury versus Madison case, and I know we've talked about that in this committee earlier. But Cooper is misconstruing the Marshall ruling. Chief Justice Marshall was merely asserting that the court can, in fact, nullify an act of Congress by ruling it unconstitutional. Nowhere does Marshall assert that the court has exclusive authority to rule on constitutionality. In fact, quite the opposite. He wrote this: the particular phraseology of the Constitution confirms and strengthens the principle that a law repugnant to the Constitution is void, and the courts, as well as other departments, are bound by that instrument. Now, the Attorney General also cites Cooper v. Aaron to assert the supremacy of the federal judiciary and that its rulings cannot be challenged. That case also rests on this same bastardized interpretation of Marbury. Such a notion obliterates the constitutional system, making the court the de facto sovereign. I shouldn't have to point out the absurdity of the court making itself supreme. It's like King Arthur claiming supreme executive authority because, in the words of Dennis and Monty Python and the Holy Grail, some watery tart threw a sword at him. Ronald Reagan, Attorney General Edwin Meese, said this about the Cooper decision. He said, the logic of Cooper versus Aaron is at war with the Constitution, at war with the very meaning of the rule of law. We need look no farther than the Dred Scott case, which was brought up just a few minutes ago, which denied even free black citizenship and went on to proclaim black people as inferior, to see the inherent flaw in this idea of judicial supremacy. Do you really accept that the Dred Scott was legitimately the law of the land even for 1 minute? Abraham Lincoln certainly did not. In response to the ruling, he said this: if the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. Fact: the Attorney General tells us that only the federal court can determine constitutionality. Fact: Ronald Reagan, Attorney General Edwin Meese, Abraham Lincoln, James Madison, Thomas Jefferson all disagreed. Jefferson said this, and I think what we need to do here while we're considering this bill is to try to unravel his logic. He said the states are not united in the principle of unlimited submission to their federal government, and the government created by this compact, the Constitution, was not made the exclusive or final judge of the extent of powers delegated to itself. Simply put, the people of the states delegated the federal government its power in the first place. As Madison said, the states then, being parties to the the constitutional compact in their sovereign capacity, it follows of necessity that there can be no tribunal above their authority to decide in the last resort whether the compact, the Constitution, made by them is violated, and consequently, that as parties to it, they must themselves decide in the last resort such questions as may be the sufficient magnitude to require their interposition. Thank you very much.